Andrew, a notary public in New York, engages in several problematic actions. He charges a client more than the legally allowed fee for notarizing an affidavit. He never took or filed his required oath of office after receiving his commission, yet he continues to perform notarial acts. Andrew also issues a false notarial certificate with the intent to deceive a mortgage lender about the date a borrower appeared before him. In addition, he drafts and charges a fee for preparing a will for a neighbor despite not being an attorney. Finally, when Andrew forges a deed, he assumes that this act, if discovered, would merely constitute a Class E felony. Which of the following statements are accurate under the laws provided? 1. Charging more than the statutory fee for a notarial act can subject Andrew to treble damages in a civil action. 2. Acting as a notary without having taken and duly filed the required oath of office is a misdemeanor. 3. Issuing a false certificate with intent to defraud is a Class E felony. 4. Preparing a will for another person for a fee without being admitted to practice law is unauthorized practice of law. 5. Forging a deed, which is an instrument affecting a legal right, is a Class E felony. So let's have a look at each of these statements once again as applied to the relevant law to help us determine the solution. Statement 1. Charging more than the statutory fee for a notarial act can subject Andrew to treble damages in a civil action. If we have a look at Section 67 found in the Notary Public License Law booklet entitled Fees of Public Officers, we can jump to Section 2, which states, an officer or other person to whom a fee or other compensation is allowed by law for any service shall not charge or receive a greater fee or reward for that service than is so allowed. And we can jump to Section 4 for the penalty in such regard. An officer or other person who violates either of the provisions contained in this section is liable, in addition to the punishment prescribed by law for the criminal offense, to an action in behalf of the person aggrieved in which a plaintiff is entitled to treble damages. So indeed, Statement 1 is accurate based on the law that I just read from, and we can put a check mark next to it. Statement 2 states, acting as a notary without having taken and duly filed the required oath of office is a misdemeanor. If we have a look at the Public Officers Law section of the Notary Public License Law booklet, it states, notary must not act before taking and filing oath of office. The Public Officers Law section 15 provides that a person who executes any of the functions of a public office without having taken and duly filed the required oath of office as prescribed by law is guilty of a misdemeanor. A notary public is a public officer. So Statement 2 as well is accurate based on what I read from just now, and we can put a check mark next to it as well. Statement 3 states, issuing a false certificate with intent to defraud is a Class E felony. If we have a look at Section 175.40 of the Notary Public License Law booklet entitled Issuing a False Certificate, it states that a person is guilty of issuing a false certificate when, being a public servant authorized by law to make or issue official certificates or other official written instruments, and with intent to defraud, deceive, or injure another person, he issues such an instrument or makes the same with intent that it be issued, knowing that it contains a false statement or false information. Issuing a false certificate is a Class E felony. So based on this law, Statement 3 is also accurate, and we can put a check mark next to it. Statement 4, preparing a will for another person for a fee without being admitted to practice law is unauthorized practice of law. If we have a look at the Judiciary Law section of the Notary Public License Law booklet, particularly Section 484 entitled None But Attorneys to Practice in the State, it makes it clear that notaries public who are not attorneys may not practice law, and that includes, if we go to the middle section here, preparing instruments such as deeds, etc., and it specifically lists wills as one of them. So therefore, Statement 4, in stating that preparing a will without being admitted to practice law is unauthorized practice of law, is accurate. We can put a check mark next to that as well. And finally, Statement 5, forging a deed, which is an instrument affecting a legal right, is a Class E felony. If we have a look at Section 170.10 of the Notary Public License Law booklet entitled Forgery in the Second Degree, it states that a person is guilty of forgery in the second degree when, with intent to defraud, deceive, or injure another, he falsely makes, completes, or alters a written instrument which is or purports to be, or which is calculated to become or to represent, if completed, number 1, a deed, will, codicil, etc. So clearly the case in question here falls under this section, and if we look below, the penalty is forgery in the second degree is a Class D felony. However, Statement 5 states that it would be a Class E felony. So therefore, this statement is inaccurate, and we should put an X next to it. So with all this in mind, let's have a look at the 4 choices to determine the solution. Choice A states 1, 2, 3, and 5 only are accurate. This is incorrect because actually Statement 4 is also accurate, whereas 5 isn't, and therefore choice A is not our solution. Choice B states 1, 2, 3, and 4 only. This is our solution based on having check marks next to 1, 2, 3, and 4 above, but not 5. But to be in the habit of looking at all 4 choices, let's have a look at choices C and D. Choice C states 2, 3, 4, and 5 only. This is incorrect because 5 is not accurate, whereas 1 also is, and that's not listed here, and therefore choice C is not our solution. And finally, choice D states all of the above. This is incorrect because 5 is not accurate, as I've already stated, and therefore choice D is not our solution either, which indeed leaves choice B, 1, 2, 3, and 4 only, as the correct solution.